Welcome, friends, in AEFC, Part 10. Argue in English fluently and confidently, Part 10. We will focus in this part on succession matters. Yes, property matters, succession matters, corporate matters, civil matters. Will give you huge wisdom, huge logical thinking practice. So this is the special, and you can earn more money also in such type of matters as compared to criminal matters. I'm not discouraging you from criminal matter, but if you want real reputation, if you want real fame, if you want real money, satisfaction, so whatever matter you comes to criminal, civil, property, succession, take all matters. Put your 100% efforts in that. In admission hearing, at drafting, at every stage. When you receive High Court order, from that point till final disposal, at each and every stage. What are the stages in Supreme Court? High Court order comes, then we will read High Court order. Then we guide client how you will get against this order relief in Supreme Court. What are the good points? If you show good point, that he will give you the case, otherwise or not. There is a tough competition in Supreme Court. So many lawyers, thousands of lawyers in Supreme Court practice. 25,000 lawyers. Competition is here. So you have to study that High Court order in well manner. Guide your client properly so that he will give this case to you. Discuss on fee. Your fee should not be very less. Your fee should not be very exorbitant. It should not be so expensive. You should not be a so expensive lawyer at initial stage, unless and until you get good pay. Moderate fee should be there. But which are points, good point, and what efforts you will take, you have to explain to all your clients. Then matter comes to you, document comes to you. Your drafting team, your filing team, your research team will work on that. As my law firm, I am more than practice for about 32 years, 33 years. So I developed my practice team properly. So drafting, research, everything taken care by my juniors, my associate lawyers. I'm arguing counsel, I'm arguing case. But as per our instruction, my instruction, because I have to argue the case, I have to give proper instructions. So this question of law should be there, this ground should be there, this should be highlighted, we should be highlighted, like that. So as per my instruction, drafting team draft the case, research team put the case laws, citations in that. Case comes to me. Then we will file this case. We will send the draft to party to approve. Party C, if party wants to add 1 or 2 document point, we will add that. Then we will file that. After filing, defect clearation, defect clearing process, defect clear process after admission hearing. In admission hearing, matter will accept or reject. If it accept, then notice issue. After notice, counter affidavit will come. Registry process is there. Counter affidavit will come. Then we have to give rejoinder if we wish. And then after notice hearing. And then final disposal. So these are the stages in my court, Supreme Court of India. At one glance, in 1 minute or 2 minutes, if we have to cover this stage, read High Court order, guide your client properly, take documents from client, draft the case nicely, send drafted case with citation and everything, synopsis, every proper draft to client for approval, After approving that clients with his suggestion at that point, then file this matter, then clear the defect, then admission hearing, then notice issue or notice or case dismiss. If notice issue, then counter affidavit will come. Then if you want to give rejoinder, you can give rejoinder. Then after notice hearing, and then final disposal. These are the stages. Sometimes we are not petitioner, sometimes we are respondent. Case already get admitted, respondent comes to us, then we have to file our Wakalatnama affidavit format, because in my law firm, 5 AOR advocate of record who are filing these cases. And through any AOR, we are filing that cases then, and then counter affidavit we are giving, and we are countering that case. How that case will get dismissed from Supreme Court when we are respondent. So our focus will be dismiss that case. And when we are petitioner, our focus will be admit that case. So sometime in one day, we have to do both the things on a same bench. Before same bench, we have to fight for admitting that case. And before same bench, after some item numbers, we are respondent. So we are striving to dismiss that case. So this is the practice part with the grace of God's grace. Okay, we'll start this part 10. As usual, from 10s, you have huge practice till part 8. I'm not repeating that. Just I will show you 1000 verbs which in your study material, which are the legal verb. Take any 10 verbs and practice daily. Daily it requires 10 to 15, max to max 20 minutes. But present tense, past tense, future tense, and each tense of 4 types: simple, continuous, perfect tense, past perfect tense. We have taken this huge practice till 8 part. So you do this, pause this video, complete this practice, and then watch my next part. Welcome back. I hope you have practiced that next your 10 verbs in all 4 tenses, in all 3 tenses with 4 substances. That means 12 tenses. You will get huge practice. Then, now, vocabulary. I already given a vocabulary book. Take from that book 5 or 6 new words. Practice that. Okay. And after this practice, now we are on our next stage, because our course is argue in English fluently and confidently. So main motto is to improve your legal English with legal accuracy, with arguing skill, with good art of drafting, everything. So all you are getting in this, and all type of cases: property matter, army matters, criminal matters, quashing matters, SLP matters, all type of cases we are observing in this small course of 16 parts. You are very lucky, friends. When I was initiated by practice in 1989, such type of thing was not that. We have to do hard work to learn all this. And now I am giving you directly original draft, arguing skill, everything. So our next part in this part is 2 videos of stalwarts. In that video, you will get new vocabulary, you will get new legal knowledge. So let me share you first video. This is our part 10. This is the video links. These are the video links. First video I am giving you, there is no profession thrilling than legal profession. So greatness, thrillingness of legal profession. Our Justice Nageshwar Rao, Supreme Court Justice Nageshwar Rao has delivered this lecture. Now he is retired from Supreme Court. I'm just copying this. Now I'm pasting that link here in YouTube. You can find my more than 300 videos on YouTube and on my app, Jayprakash Somani, Supreme Court app, you will find so many courses, small courses also. Help in criminal matters, help in property matter, like that.
Judges of the Kerala High Court, judges from Andhra Pradesh, Telangana High Court. Learned Advocate General, my advocate friends and my dear students. Good morning. At the outset, I should tell you about the appreciation I have from the association for having this continuing legal education program. Roscoe found
Friends, as per our instruction, you should watch this video 3 times. First, enjoy the subject, enjoy video, enjoy your knowledge, legal knowledge. Second, play, pause, find out the new vocabulary. Find out its meaning from dictionary. Then read each word 5 times with its meaning. Then third time, watch this video again. Not a single new word is for you. And now you can get an expertization day by day. This is the first video. Now I am sharing you second video. Link is in your study material. You have to copy that link and paste in YouTube. Here I copy. Then I'm pasting. Which is this video? I will explain. Justice Nariman's address on descending judgment in 50s and 60s. In 15 and 16s, descending judges judgment. Suppose a constitutional bench of 5 judges, 4:1. So 4 judges in favor, 1 judges in dissent. So descending judges' views of 15 and 16, how judges are descending and how new law, new philosophy, new jurisprudence takes birth from descending judges' judgment also. Justice Nariman is my hero in Supreme Court. Now he is retired. And he is the son of senior advocate Phali Nariman. Rohinton Nariman was our senior advocate in Supreme Court Bar Association in Supreme Court and directly elevated from Supreme Court Bar Association to Supreme Court judge. They don't have experience of High Court judge. Yes, such type of things happens when you have extraordinary talent extraordinary acumen, legal acumen. When you have, then you can create this. Many judges are there who are elevated directly from SCBA to directly Supreme Court, from directly High Court or Supreme Court Bar Association to directly High Court judge. Some are elevated. So this is the great task. And I'm very happy to say that when this offer of a Supreme Court justice, when government has given, Chief Justice has given to senior advocate Rohinton Nariman, at that time his practice was in crores. And after accepting this post, his earning was in lakhs. So straight down earning reduces, efforts high, and 5-6 years, whatever he has devoted as a judge, he has given extraordinary judgments in corporate matters, specifically insolvency matters, in all matters, but specifically he is very expert in insolvency, corporate matters. So each and every video is very important. And he always wants to deliver lectures on different subjects, which ordinary people are not doing. So this is the special characteristic of this hero, Rohinton Nariman. So as usual, I will show you is just a talking style.
There are differing voices. So it was always a tradition with the America that they delivered usually one judgment which spoke for the entire bench. Chief Justice Nagar's autobiography gives us an interesting insight.
Very good vocabulary you will find in this video as per our instruction. First, enjoy video, enjoy subject. Second, play, pause, find out difficult word as per your accuracy. And third, find out difficult word, then find out its meaning from dictionary. You have to take these efforts. That time your vocabulary can enrich. And which new word you find, would write its meaning and practice it 5 times. Then again watch this video and see not a single word is new for you now. You can enjoy the subject now. So all these 2 videos, you have to take care of vocabulary and practice it. Pause here, practice that, and then comes to next part. So comes to next part of this part 10. Thank you very much. I hope you practice that 2 videos very well, or if not practice, after finishing this video, you can practice, no doubt. But remember that whenever you follow my all instructions in all part, just follow all instruction and practice according to that, you will definitely become stalwart lawyer in High Court and Supreme Court. And if you like trial court, because I already mentioned in part 9, if you want good satisfaction in lawyership, practice in trial court. You will get good satisfaction. Appellate court, you will not get good satisfaction. You will get money, you will get little bit fame also, but not satisfaction. Not full satisfaction as compared to trial law. I'm not discouraging to come to apex court, but you have a different eye for practicing apex court, specifically Supreme Court. So now Next part of this, part 10, is our succession matter. And at the initiation of starting point of this video, we have seen the stages. First, we should see High Court order. Let me read the High Court order. See, this is the High Court order of Kamakhya Prasad matter. This is the Municipal Court judgment of Kamakhya Prasad matter. This is Civil Court judgment in Kamakhya Prasad matter. This is the full SLP in Kamakhya Prasad matter. This is the Indian Succession Act. This is the Hindu Succession Act. On my app, you will find so many laws. Free of cost are also so many there, and in your study material are also so many there. And you can easily find out Bare Act on India Code website. So that is not a big deal. Now, High Court order. Kamakhya Prasad. So Jagannath Prasad Gupta, Bhola Prasad Gupta, Radha Krishna. These are all are Kamakhya Prasad sir. Chandrika Prasad versus. Third Learned Council, Miss K. Yadav for the appellant, and Learned Council, Mrs. P. Chatterjee, Mrs. or Miss P. Chatterjee, P. Chatterjee for the respondent. It is submitted by the Learned Council for both the sides that application under Order 1 Rule 10 CPC filed in SAO 10 of 1999 could be traced out, could not be traced out, and as such, the said application was not bid tagged. However, it is submitted by the Learned Council for the both the sides that the copy of the said application is available with the Learned Council for both the sides. Since the matter is very old one, pending of more than 10 years, it is deemed appropriate to reconstruct the record arising out of the application under Order First Rule 10 CPC filed in SAO 10 oblique 1999. Registry shall take steps to reconstruct. So this is not a final order of High Court, which we have to challenge. This is the interim order. Final order we will get in SLP draft. This is Civil Court order. This is SC order. In full bunch, we will find High Court order, final order. So I will show you full bunch, and in that full bunch, we will see that order. So if you take full bunch copy, you will find all lower court order, municipal court order, all court. Jagannath Prasad Gupta. Why I am telling you Kamakhya Prasad Gupta? Because Jagannath Prasad Gupta's father was Kamakhya Prasad and grandfather of the petitioner now who comes to us. So this is the, see the annexures, how many annexures we join here in this succession matter. First, we'll, after synopsis and list of date, we will find High Court order on page number 1. Till High Court order, all pages are A to Z like that. A, B, C, D, E, F, G, H, I, J, K, L, M, N, O. So here, list of date completed, and after list of date, you will find impugned order, High Court order, which we have to read. See, this is the retype order. Heard Mr. R.L. Yadav, a learned counsel for appellant. Same appellant who is a petitioner, yes, he is appellant in High Court. He defeated a case in High Court, so he comes to Supreme Court. Pause video here, take the printout of this all full bunch and then listen it. That will be better. Not now, but after some time you can do that. The instant appear under section 100 of the Code of Civil Procedure has been filed against. Instant appeal, not appear, is a typo error. Instant appeal under section 100 of the Code of Civil Procedure has been filed against the judgment and decree dated 30/7/1999, passed in TA number 599, whereby the judgment and the decree dated 28/1/1998 in title suit number 6194 by the Court of Civil Judge Junior Division, Bongaigaon, was set aside, and the first appellate court wide impugned judgment and decree held that the suit land is the paternal property of the three sons of late Ram Prasad Kalwar, and the plaintiff are of the son of Kamakhya Prasad Gupta, who is one of the son of Rama Prasad Kalwar. And as such, defendant and plaintiff are held entitled to 1/3 share each. This court wide the order dated 23/2008 frame 3 Sorry for interruption due to failure of network connection. Let me share you again that order. So para 2 of High Court order was reading, we are reading. The instant appeal under section 100 of the Code of Civil Procedure has been filed against the judgment and decree dated so and so, passed in title application number 599, whereby the judgment and decree dated so and so, and title suit number 6193/94 by the Court of Civil Judge Junior Division, Bongaigaon, was set aside, and the first appellate court, while the impugned judgment and decree held that the suit land is a paternal property of the three sons of the late Ram Prasad Kalwar, and the plaintiff are the son of Kamakhya Prasad Gupta, who is one of the son of the Rama Prasad Kalwar, and as such, the defendant and plaintiffs are held entitled to 1/3 share. This court wide the order dated 23/2008 framed 3 substantial question of laws for adjudication of the instant appeal. It said substantial question of laws so framed whether Khatian is a record of right on this document whether rights of the parties can be determined. Kaitan means that Sat Bara like that format. So in this is the case of Assam. So they are using Kaitan there. That is mutation record, you can say. Second, whether in absence of any other reliable documents, the right of the parties can be determined on the basis of the revenue receipt continuous possession of the parties. Whether the share of legal right can be determined by ignoring all legal heir who may not be party in the suit. And fourth, for the purpose of adjudication of instant appeal, it would be relevant to take note of the brief facts which led to the instant appeal. The appellant before this court is plaintiff filed the title suit before the court of the municipality at Bangaigaon, which was registered under number title suit so and so. In the said suit, the claim of plaintiff were that the suit land originally belonged to the late Kamakhya Prasad Gupta, who was the father of the plaintiff, and the said Kamakhya Prasad was possessing the said unit land by constructing dwell houses and husking mill, wherein since the time of Bijni Raj acquired estate. It has also been mentioned that the father of Kamakhya Prasad Gupta, late Kamakhya Prasad Gupta, was Ram Prasad Kalwar. Since dead, was living along with Kamakhya Prasad. So Kamakhya Prasad Gupta's father, Ram Prasad Kalwar, was living with Kamakhya Prasad at that time till his death. And late Ram Prasad Kalwar was the possessor and the owner of the plot land measuring 3 katha, 3 lecha, like our acre like that, acre gunta type, covered by DAG number 606, having khaitan number 600, new khata number, survey number you can say, 145, who was in continuous possession of the land. It was further mentioned that dependent and the late Kamakhya Prasad Gupta, being the son of late Rama Prasad Kalwar, were the owner and the possessor of the said land measuring 3 katta and 3 latches. It was mentioned that late Kamakhya Prasad Gupta got his name muted as a joint pattadar along with his father in respect to the suit land measuring 1 biga, 0 katta, 19 leches. So this is a long order, so we can skip some part and we can go on this. On the basis of pleading, as many as 6 issues were framed. Where is there any cause of action for the suit? Is the suit maintainable? Is the suit bad for the defect necessary parties? Such type of some questions are there. And what is the final decision? So on final decision, we can guide to our client. And when you find time, you can read this document. This is for your homework. Read this full order. But in regular practice, when I received a High Court order, sometimes a High Court order is of 70 pages. And I have to guide that. So reading 70 pages, such type of time we don't have. So we have to read that order starting, try to understand some facts and what is the decision of court. It is no longer res integrata that a second appeal under section 100 of the CPC is to be decided on the substantial question of law. A question of law which may be general importance would not be a substantial question of law involved in appeal until the said question of law was an impact of the decision between the parties. The contention so made by learned counsel for the appellant that first appeal court should also have considered the share of the pro forma defendant number 1 to 4 cannot be considered in the instant appeal, as instant appeal has not been prior by pro forma defendant number 1 to 4, and as such, the said substantial question of law cannot be said to be involved in the instant appeal. It is under such circumstances, and as this court does not find any substantial question of law arises in the instant appeal, stand dismissed. Registry is directed to send back the LCR for it. So this is the order. So contention is that we want that property full, not one-third share. Trial court has given order because Rama Prasad Kalwar have sons. So 3 sons are there. So that property should be shared between 3, one-third share. And our petitioner who comes to us, whose case we have taken, he told Rama Prasad Kalwar son was Kamakhya Prasad, and Kamakhya Prasad's son was Jagannath Prasad Gupta. Okay. So Kamakhya Prasad, grandfather of our petitioner. So Kamakhya Prasad Gupta's name is on mutation. Receipt, Bijli Raj receipt name is Kamakhya Prasad. But Kamakhya Prasad has taken this land from Bijli land estate in the name of Rama Prasad Kalwar. This is the contention of our petitioner. This is not a joint property. It is not an ancested property. This is the self-acquired property by Kamakhya Prasad. But Kamakhya Prasad has taken that in the name of his father. So any property in the name of father is there. And when there is no evidence properly, that time it will consider it as an ancested property in the eyes of Kamakhya Prasad and lower generation. So in this matter, first task is to find out proper tree of that. So I have given this matter to my junior to find out the tree proper. Whose son, who daughter, who, like that. Yeah. And I want full share. We want full share. Lower court has given order. You will find the lower court decision in this. Then upper lower court decision you will get. Then high court decision. High court has not interfered in that order. High court did not to interfere in that order because already appeal to office or utilized there. And Supreme Court find no substantial question of law there. But even though there is no substantial question of law, when client comes to us, we have to fight for the justice. So we have drafted this case beautifully. And this is the draft. Main question of laws is here. This is our regular, whether the impugned judgment and order passed by the Honorable High Court is justified and legally sustainable under the facts and circumstances of the case. Whether the judgment and decree dated 28/1/1998 passed by the learned civil judge, Junior Division, Bongaigaon, in title suit number 61 of 1994 filed by the plaintiff petitioner is illegal and void and binding on the respondents. whether the learned first appellate court is justified in allowing the title appeal number 9 of 99 filed by respondent, whether Khaitan record is the right, whether the Khaitan record whether Khaitan is a record of right, and on this document whether a right of parties can be determined, whether in absence of any other reliable documents, the right of parties can be determined on the basis of the revenue receipt and continuous position of the parties, whether the share of legal heir can be determined by the ignoring all legal heir who may not be party in suit, whether the first appellate court failed to consider that the respondent as a defendant failed to prove any document establishing it. So these are the question of laws. These are the grounds. So read question of synopsis properly, read question of laws property, grounds property, then prepare 10 points note for admission hearing. After admission hearing, then after notice, when counter affidavit will come, final hearing, that time prepare, elaborate that 10-point notes into properly ground, explain it properly, then final order comes to you. So this is the way of dealing, filing, practice, and do the argument in Supreme Court. So in argument, remember that three things are important: point of synopsis, some points from question of laws, and major points from grounds we have to take. And we have to show while arguing the concerned annexure. Lordship, please turn on page number so and so, annexure here. What we have drafted, the proof of that is annexures. So we have to continue to show that. Okay. And when Lordship find there is a substantial point to interfere in this order, that time they will admit this case. Other they will dismiss this case. So that is not in your hand. That is the hand of the judiciary. Try 100% from the bottom of your heart is in your hand. So do that. So put your 100% efforts in drafting, research, and arguments. So rest live in the hands of the Lord Justice, Nyaya Devta. So leave that. Karmanyeva adhikaraste ma phaleshu kadach. Sometimes case gets admitted, sometimes case get dismissed. So this happened because four courts earlier are hearing that cases. So we cannot say all four courses are wrong and we are right. So Supreme Court should give the decision in our favor. No. Sometimes it happens. All courts are negative, but Supreme Court finds some points and that can positive, but not regular. So we have to take care. We have to face this desperation, appreciation. When case get admitted, we get motivated. Some get dismissed, then we get little bit in depression. But don't bother. Tell client, we will file review, we will file curative petition. If you want to take that chance of review, take chance of curative, you can find my separate video on curative petition, review petition in on YouTube. You can find some videos of free of cost. On our app also, you will find some videos free of cost directly. So you can watch that video. But there are hopes. We have to show the hopes to the client, because when client is ready to fight for his case, then why we should not give support to him? When client come to Supreme Court, till Supreme Court, he is fighting case. So this is the matter. Don't bother. Try hard. Learn, read more. Case laws, everything, and be happy. after dismissing case also, smile and greatly oblige. So they are also happy. This advocate has got my spirit. Better luck next time. So they are always inspiring us from the bench. So thank you very much. Take the printout of this all full bunch, read it carefully, see this properly, and then from municip record, this judgment, then you comes to know. So how this case is handled by High Court, and then how we appear before Supreme, like that. Thank you very much. See you in AEFC 11 very soon. Thank you.